Mr. Evans has indicated that he'd like to represent himself on this matter and have our office as standby. I think the court granted that motion, but set this hearing to today because Mr. Evans indicated that he sent a letter to the court that had some requests in it. I don't know if the court received it and if a copy was provided to the city. I have not seen it.
I have not seen it. I looked in the court file earlier today and it was not there. Madam Clerk, do you know if we've received it?
I don't know why you guys haven't received it. Also, can I ask that this hearing is on record and that everything is being documented by a court reporter, please?
We do not have a court reporter. We're creating an oral recording though.
Okay, so will it be on record and
Yes.
Will it be able to be reviewed?
The hearing begins with confusion and curiosity as the judge addresses Mr. Evans, who insists on representing himself. The prosecutor confirms the court allowed it, but the judge reminds everyone this session was set because Evans mailed a mysterious letter filled with requests. Already, the energy shifts. He's not a typical defendant. The judge calmly asks if the clerk received the letter, but Evans immediately interrupts, demanding a court reporter and federal review access. The courtroom grows tense. It's a classic sovereign move, trying to elevate a local misdemeanor into an international case. His tone oozes confidence but hides desperation. Every sentence is a performance, a bid for recognition. This is where courtroom order begins to unravel into pseudo-legal theater, one delusion at a time.
Reach you, but the letter had very personal and sensitive information regarding my sovereignty as a chief of a sovereign tribe that's federally and internationally recognized. I don't know why that letter didn't make it to you. I mailed it out last Tuesday, so it should have definitely gotten to you guys by now. I'm having issues with getting to the law library. I've been in the hole. It's like almost impossible for me to legally defend myself with the conditions within the jail. One thing I would like to ask, especially being that you didn't get that letter and I invoke my rights as a sovereign tribe, chief of a sovereign tribe, that if possible, you can give me a PR bond so I can properly get everything to you and make sure it's filed in the courts. I assure you, being that I invoke my rights as a sovereign tribal chief, that I will appear at court dates. I won't play with my rights like that. I have too much to lose. And I have a leg injury. But the main thing is my legal part, and getting the proper defense, and then the mail that I'm mailing out, it's not even getting to you. So I know I'm gonna have an issue defending myself from the inside of this jail. If you could do that for me, I humbly, respectfully ask that you give me a PR bond so I can at least properly defend myself.
Evans launches into his speech about sovereignty, declaring himself a chief of a federally and internationally recognized tribe. He claims his mailed letter was sacred proof of that status, but somehow the court lost it. The drama unfolds like a scene from a satire. He invokes tribal sovereignty, demands a PR bond, and insists he'll appear because his rights as a chief forbid dishonor. Beneath the grand declarations, though, you hear exhaustion. He's struggling in jail, can't access the law library, and feels helpless. Yet instead of asking for a lawyer, he wraps every plea in mysticism. The courtroom isn't just hearing a bond request. It's witnessing a man rewriting reality to survive inside his own mythology.
There was a letter that was faxed in that we received yesterday, and I just forwarded it to all parties.
Okay, thank you. I'm going to take a moment to look at that then. I didn't see it in the file.
In addition to that, I introduced evidence that will exonerate me.
Mr. Evans, I can't read it and listen to you at the same time.
I'm sorry, Your Honor. Also,
Sir, I can't read and listen at the same time. I read slowly.
sorry.
Okay, I've read your letter. You've already had at least one bail hearing, because I remember it. I have not heard any change in circumstances such that you're not entitled to a second bail argument. Bail remains as previously set, $500 per charge. What tribe are you enrolled in?
All of that, I don't want to reveal that information because it's private. That's why I invoked also the Peace and Friendship Treaty between the United States and Morocco, in which I do qualify for that. And also you can contact the Embassy of Morocco.
No, so I'm familiar with that treaty, and it is a trade treaty. It has nothing to do with your right to commit crimes anywhere you feel like.
No, ma'am. It has nothing to do with me committing crimes, but they will vouch that I am royalty, and Morocco has granted me as part of their royalty, and they will vouch for me. I assure you.
You can't be a royalty in Morocco and a native.
When the judge asks about his tribe, Evans suddenly goes silent, claiming it's private information. Then, without missing a beat, he invokes the Treaty of Peace and Friendship between the United States and Morocco, claiming it grants him royal immunity. The judge corrects him sharply. It's a trade treaty, not a permission slip for crime. But Evans doubles down, insisting Morocco recognizes him as royalty and would vouch for him. The courtroom sits in stunned disbelief. The moment is absurd yet fascinating. A man standing before a city judge, declaring dual citizenship as both Moroccan royalty and Native American chief. It's delusion dressed as diplomacy, and the judge handles it with quiet professionalism.
Received no evidence. I received just your letter.
Right.
So I'm not going to. I'm not going to grant your motion to dismiss.
Okay.
What are we doing?
Okay. And I submitted evidence in the letter.
I'm not denying. I'm not granting a motion to dismiss.
I understand, but I submitted evidence in the letter as well.
I've considered your letter, and I'm not granting your motion to dismiss.
I understand.
Okay, what are we doing?
What about the evidence?
What do you want me to do with the I don't have any actual evidence. I have your statements.
Right, I submitted evidence in the letter. If you read it, you'll see that I submitted a civil case as evidence.
You submitted, you mentioned a civil case. I don't see the civil case. I have no access to this case.
I submitted civil case 24012 out of St. James Parish, Louisiana, as evidence that will exonerate me. And in addition to that, it will prove everything that I'm saying to be true.
I don't have that case, sir, is what I'm telling you. All I have is your letter.
Right. In the letter, I submitted civil case 24012 out of St.
Sir, I don't have that case in front of me. I don't know what's in it. I have no access to it. All I have
You
is...
have to retrieve it.
I have no way to do that.
You have to
That's not your
contact
job.
the courts.
Sir, that's your job. This is your case. You represent yourself. It's your job to put your case together. It is not the court's job.
As the judge reads his letter, Evans interrupts repeatedly, insisting he included evidence that will exonerate him. He believes a civil case in Louisiana proves everything, from his innocence to his tribal sovereignty. The judge, patient but firm, explains she only received a letter, not evidence. Evans won't hear it. To him, the letter itself is evidence. Words that become law the moment he writes them. His belief system turns paperwork into power, and he's convinced the court simply refuses to see it. The exchange is surreal. One side anchored in law, the other floating in imagination. It's not a battle of arguments anymore. It's a collision between belief and...
I submitted civil case 24012 out of St. James Parish, Louisiana, as evidence that will exonerate me.
Then you have to actually get that case and put it before the court.
It's impossible for me to do that inside jail.
You have a standby counsel. Perhaps you can talk to him about it.
Are you going to be able to retrieve that case for him?
1 second. And Your Honor, I can make the records request. I don't know if it's going to have any luck receiving it. I mean, based on the information that I have.
The case has a seal on it, and you're going to have to get permission from the Chief Justice Roberts to get the seal broken.
I don't understand what the U.S. Supreme Court has to do with a Louisiana state case.
Because it holds my rights, as my constitutional rights and privileges as a chief of a federally and internationally recognized tribal chief, in which I represent a sovereign state.
Okay, so what are we doing today?
According to the letter, if you're not going to dismiss it, I asked that, in the letter, I requested that you file a motion of discovery.
I can't file any motions. I'm not an attorney. I don't represent you. I don't represent the city. That is not my role.
Okay, and you said you're not dismissing due to lack of evidence.
Correct. I have read the police reports and did find probable cause to detain, and some of these cases are in review status. They've already been.
Evans insists the Louisiana case 2412 is proof of his innocence, but he never actually provides it. The judge reminds him it's his responsibility to present evidence since he chose to represent himself. She can't and won't investigate for him. Still, Evans argues it's the court's job to retrieve it, demanding an impossible favor. The room stiffens with quiet frustration. Even his standby attorney admits the case might be sealed and would require permission from Chief Justice Roberts. An absurd escalation that makes the judge blink in disbelief. Every claim digs his credibility deeper. What began as self-representation is quickly becoming self-destruction wrapped in conspiracy.
Focus on what we're doing today. I've denied your motion. We need to move on.
Yes, ma'am.
Okay, so what are we doing today? What's the plan going forward?
The plan going forward, I would like a fast and speedy trial by jury. I would like a motion for discovery to be filed. I would like a motion to suppress.
Sir, you represent yourself. You have to file those motions. Nobody, you asked to represent yourself. You got, Judge Rose Akins granted that. So it's up to you to file those motions.
Okay, I just received the paperwork from Mr. Iannetti today on the format to file those motions, so I'll have those motions mailed out tonight.
Okay, perfect. All right, so we're setting this for trial, is what I'm hearing.
By jury.
Okay, so only the pretrial cases are going to be set for trial. I see the pretrial order has all the case numbers on it. Or does it have only the pretrial one? Okay.
I just clicked on it to give him an example of that order as well.
No, I think you've got all the right ones on here.
Okay.
1-5.
And I also asked that that letter be sealed due to the fact it has sensitive information on there regarding me and
You
my
have to
family.
file a motion to seal it, sir. I'm sorry, but this is why it's best not to represent yourself if you don't know criminal procedure. There's a whole process to having something sealed. I have to make certain findings. I don't have that motion in front of me.
Okay, I requested it in the letter, but I'll file a motion as well.
Okay. But I'd encourage you to read the Bone Club case so that you can understand what the guidelines are for sealing.
I haven't received any of that information, and also I need access to the law library, which is like I don't have any.
The conversation spirals further when Evans tries to tie his Louisiana civil case to constitutional rights as a sovereign tribal state. His logic stretches across continents, connecting his jail cell to foreign diplomacy and royal lineage. The judge, maintaining calm authority, keeps bringing him back to reality. What are we doing today? It's the voice of law pulling him out of fantasy. Evans pivots again, now asking for a motion of discovery and dismissal, both of which he expects the judge to file. She refuses, reminding him he's his own lawyer. The tension is thick, but the lesson is clear. Sovereignty fantasies crumble under the weight of courtroom rules.
Police reports, that's it.
Will the city, first of all, is there a motion to join and consolidate these cases for trial?
Yes.
Any objection, Mr. Evans?
Yes, I do have an objection.
So then you realize it'll take roughly 4 months to try these cases.
Will I be sitting in jail the entire 4 months, or is it 60 days still?
The problem is we can't try, if you're not going to agree to try them simultaneously, I can't guarantee you they'll all be tried within, we only do jury trials 1 week out of the month.
But my question is, will I have to sit in jail 4 months or 60 days?
Potentially 4 months. I can't rule that out. And I'm not trying to pressure you into agreeing. I'm just setting out the facts. You do what you want to do.
I just explained what joinder means and the benefits and disadvantages of joinders.
So, Mr. Evans, what do you want to do?
I want to do them all separately.
Okay. We'll set them, here's what I'm going to suggest then. I'll put this out to you guys. You tell me what you want to do. Set them all in the June term, and then whichever one goes. But we'll have them all set so that it'll depend on who's available and such, okay? But they are not joined, that unless somebody files a motion, I actually hear it, but as of now, nothing is joined, okay?
Yes, Your Honor.
So the readiness hearing will be on June 12th.
Sit out here.
And jury trial beginning the week of June 24th. And we'll have a hearing on admissibility we'll have a 3-5 hearing. That's a hearing about any statements you may have made, Mr. Evans. And a hearing on admissibility of any 911. I don't know whether there is or not, but just in an abundance of caution. Will you be filing any motions to suppress under Rule 3.6?
I'll be filing motions to suppress and subpoena.
Are there additional witnesses?
As the judge denies his motion to dismiss, Evans still insists he filed evidence through his civil letter. His voice carries a strange mix of conviction and confusion. He's trapped in a loop where belief replaces fact. The judge carefully explains probable cause, referencing police reports and prior convictions, grounding everything in law. But Evans hears only injustice. To him, every refusal proves corruption. Every legal explanation feels like betrayal. The courtroom becomes an echo chamber where he's both the victim and the hero of his own story. Watching it unfold feels like witnessing a man arguing with a reflection. Confident, persistent, and hopelessly lost.
Ms. Chenwaller, is including SeaTac airport operations sufficient to put the city on notice of who the defendant will be calling?
No.
Okay. What would you accept? I don't know how to put this, because I don't think Mr. Evans knows who this is right now.
I believe the onus is
director
on the
of the
defendant
airport.
if he wishes to identify and subpoena that individual or individuals.
Okay, so as soon as you figure out who it is, you have to put the city on notice.
Lance Little, the managing director of the airport.
Okay. SeaTac Airport Managing Director Lance Little. I've included that.
Got it.
Will you be offering any affirmative defenses?
Is that a question to me or the?
Yes, it is. It is.
What's your question again? I'm sorry.
Are there any affirmative defenses?
Could you reword that, please?
Perhaps Mr. Ainati can help.
Yes, 1 second.
Yes, ma'am, I do. I will be providing an affirmative defense and the right that I was a law-abiding citizen at the airport.
So I think that's general denial. That's not an affirmative defense.
Well, also that I was a passenger of a business that operates legally in the airport, of a charter bus company that legally operate. I was a customer of a charter bus company that legally operates in the airport.
So still, that's just general denial. That's saying, I didn't do it. Not an affirmative defense is saying you did it, but there was that you were allowed to do it.
Right. I was at the airport, and the reason why.
So that is general denial. That is saying there was no crime that was committed. That's what you're saying, right? That you did not commit.
When asked what he wants next, Evans demands a fast and speedy trial by jury and motions for discovery and suppression. Again, the judge reminds him that since he represents himself, he must file those motions. His misunderstanding of procedure becomes painfully visible. The judge's tone stays respectful but firm. This isn't a sovereign seminar. It's a criminal court. She schedules trial dates while he nods in defeat, realizing how tangled his self-defense has become. It's a rare moment of humility in the chaos. Yet even then, he can't resist asking to have his sensitive letter sealed. One final attempt to protect his fantasy from public light.